Tuesday, March 31st, 2026. AGNDD, Intelli Report topic. Justices reject Colorado law banning conversion therapy for L.G.B.T.Q minors. Please pardon any visual and informational inaccuracies in this partially AI-generated article-based video. Justices reject Colorado law banning conversion therapy for L.G.B.T.Q minors. The state and more than 20 others restrict therapists from trying to change the gender identity or sexual orientation of L.G.B.T.Q clients under the age of 18. By Annie Marimo, The New York Times, reporting from Washington, March 31, 2026, updated 12:46 p.m. ET. The Supreme Court on Tuesday overwhelmingly sided with a Christian therapist, rejecting a Colorado law that prohibited mental health professionals from trying to change the sexual orientation or gender identity of LGBTQ minors. The court's decision has implications for more than 20 other states that have similar laws barring so-called conversion therapy and is a major win for conservatives. Critics and major medical organizations say such therapy is ineffective and potentially dangerous for young people. But in its 8-1 decision, the court said the law, as applied to talk therapy, represented an egregious assault on free speech and the First Amendment. Colorado may regard its policy as essential to public health and safety, Justice Neil M. Gorsuch wrote for justices from across the ideological spectrum, but the First Amendment stands as a shield against any effort to enforce orthodoxy in thought or speech in this country. Two of the court's liberal justices, Elena Kagan and Sonia Sotomayor, sided with the majority. Only Justice Ketanji Brown Jackson dissented, reading a lengthy summary of her opposition from the bench. Justice Jackson warned of the broader implications for medical care that she said could be catastrophic if states cannot regulate some kinds of speech by licensed professionals. This decision might make speech-only therapies and other medical treatments involving practitioner speech effectively unregulatable, she wrote, criticizing her 8 colleagues for having made this momentous decision without adequately grappling with the potential long-term and disastrous implications. In recent years, the Supreme Court has issued a series of decisions in favor of religious people, notably conservative Christians, though it has generally been divided on those issues along ideological lines. Colorado's statute, adopted in 2019, prohibits any practice or treatment that tries to change a minor's gender expressions or to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex. State officials have never enforced the measure, which includes fines of up to $5,000 for each violation and possible suspension or revocation of a counselor's license. The law includes a religious exemption for those engaged in the practice of religious ministry. Kaylee Childs, an evangelical Christian, sued the state over the law in 2022, contending it prevented her from working with young patients who want to live a life consistent with their faith. A lawyer for Mrs. Childs, Jim Campbell of the Alliance Defending Freedom, called the decision a significant win for free speech and common sense. States cannot silence voluntary conversations that help young people seeking to grow comfortable with their bodies, he said in a statement. In her court filings, Mrs. Childs said she was not seeking to cure clients of same-sex attractions or to change their sexual orientation, but rather to help patients with their own stated goals, which sometimes include seeking to reduce or eliminate unwanted sexual attractions. Mrs. Childs' legal team told the court that the law should be subject to a demanding standard of judicial scrutiny that would require the state to show that its law advances a compelling government interest and is narrowly devised to do so. They say that if the law were subject to that higher standard, known as strict scrutiny, courts would find that it surely violates the Constitution. The therapist's position was backed in court by the Trump administration. Colorado's Democratic Attorney General Phil Weiser defended the law, saying states have long regulated medical practices, including treatments carried out through speech, to protect patients from substandard care. He had warned that a Supreme Court ruling against Colorado would undercut the ability of states to regulate other professions and make it harder to sue all kinds of professionals, including doctors and lawyers, for giving bad advice. Mr. Weiser called the court's decision on Tuesday a setback for Colorado's efforts to protect children and families from harmful and discredited mental health practices, and he said in a statement that it limits the authority states have long exercised to safeguard patients from substandard care. He said his office will review the decision to determine its full impact on Colorado law. Kelly Robinson, the president of the Human Rights Campaign, said in a statement that the decision would undermine critical protections for young people in 23 states and the District of Columbia, leaving children vulnerable to abusive and ineffective practices that harm families and devastate mental health outcomes. The Colorado therapist case was heard a few months after the court's conservative majority upheld a Tennessee law barring certain medical treatments for transgender youths that the state deemed unsafe. In January, the justices also heard challenges to state laws in West Virginia and Idaho prohibiting transgender athletes from participating in girls' and women's sports. A ruling in that case is expected by this summer. In 2023, the court sided with a web designer in Colorado who said the First Amendment allowed her to refuse to design wedding websites for same-sex couples. In 2022, the court said a high school football coach had a constitutional right to pray at the 50-yard line after his team's games. In general, the First Amendment prevents the government from restricting speech because it dislikes the content or message, but the Supreme Court has said certain restrictions aimed at governing a person's conduct are permissible even if they incidentally burden speech. In its opinion on Tuesday, the court rejected Colorado's claim that the law represented the traditional licensing of the practice of medicine and only incidentally prohibited Mrs. Chili's speech. Instead, the state's law trains directly on the content of her speech and permits her to express some viewpoints but not others, Justice Gorsuch wrote. The majority acknowledged that the question of how best to help minors struggling with issues of gender identity or sexual orientation is presently a subject of fierce public debate. But it concluded that Colorado's law clearly censors speech in violation of the First Amendment. Every American possesses an inalienable right to think and speak freely and a faith in the free marketplace of ideas as the best means for discovering truth, the opinion said. However well-intentioned, any law that suppresses speech based on viewpoint represents an egregious assault on both of those commitments. Justice Kagan, joined by Justice Sotomayor, wrote separately to explain why the decision to reject Colorado's law was not a close call. The law, Justice Kagan wrote, chooses sides based on the speaker's opinion and permits only speech on one side of an ideologically charged issue. As an example, Justice Kagan said the law prevents a therapist from saying she can help a minor change his same-sex orientation but permits her to say that such a goal is impossible, and so she will help him accept his gay identity. Because the state has suppressed one side of a debate while aiding the other, the constitutional issue is straightforward, she wrote. The issue had split the lower courts. An appeals court in Florida found a set of similar local laws restricting therapy in the state was unconstitutional. A divided panel of the U.S. Court of Appeals for the 10th Circuit sided with Colorado, finding that talk therapy provided by a mental health professional is a medical treatment that can be regulated as part of the state licensure process. Anne E. Marimo covers the Supreme Court for The Times from Washington. Comments? Ryan, Brooklyn, 2 hours ago. Justice Jackson is clearly correct. The therapists are perfectly able to speak any of their opinions under the law. They just can't call it health care, and do it under the auspices of being a licensed therapist. Does this mean doctors are now allowed to lie and give harmful medical advice just because it's speech? Wayne C., Portland, 2 hours ago. I thought there was a distinction between civil speech and commercial speech. This therapist is selling her services, therefore any speech she engages in during her session is commercial, and the state can regulate that in ways it cannot regulate civil speech, which is intended to let people publicly air grievances. Jim, St. Paul, Minnesota, 2 hours ago. This issue is considerably more complex than it first appears. This is not merely an issue of protected First Amendment rights. The state frequently pays for talk therapy. Conversion therapy has scientifically been proven to be both ineffective and injurious to the client. Therefore, allowing conversion therapy to continue is to require taxpayers to fund a scientifically ineffective and dangerous treatment. Can you imagine something like this happening in any other aspect of medical practice? The Supreme Court justices were not qualified to render this decision. AJ, California, 2 hours ago. So if I go to the doctor and the doctor diagnoses me with cancer, but tells me fervent prayer is my best hope for recovery and chemotherapy is sinful, that doctor gets to keep their license? R.W., Denver, Colorado, 2 hours ago. If talk therapy is First Amendment protected speech not subject to regulation by the states, one wonders how the services of attorneys can be regulated by state bars, given that their services are almost entirely that of speech, whether written or spoken. Even Justice Kagan's concurrence does not address this point. I suspect that the answer is simpler. This court has never met a victimized Christian plaintiff it doesn't like, even if, as in this case and the 303 Creative case, that plaintiff faces no real risk of the law being enforced against her. Boulderite, Colorado, 2 hours ago. This makes everything harder all round. I'm not just saying that because I'm the parent of a trans child in Colorado. As I read it, this ruling means that if someone is lucky enough to find a therapist, they seem heavily booked these days, then they are then going to have to figure out if the therapist is low-key pushing some weird agenda, which could range from Scientology to cryptocurrency. That could take a long time to come out. That's why, in my opinion, therapy should be regulated, especially in the current age of quackery. Adrian, Massachusetts. 2 hours ago, I think a medical panel review would have been better than 9 people in black robes. The Heartland. 2 hours ago. Mark my words, this Supreme Court will have blood on its collective hands when this pseudo-therapy fails people, particularly young people. You can't pray the gay away. Vincent, Alabama, 3 hours ago. I assume the same ruling holds true for state laws banning abortion counseling. Margaret Garside, Medford, or 2 hours ago. It's not therapy, it's abuse. The Prof, Maine, 2 hours ago. This is the same faulty reasoning as in previous decisions. One can modify the human brain through images and sounds just as easily as by drugs. Much of advertising and social media are specifically designed to take advantage of the ability of speech to cause addiction. Thus, the notion that speech should be protected without qualification, yet drugs can be regulated, is based on a fallacy. We need a more nuanced understanding of speech in this country. Eric, Philly, 3 hours ago. Does this work both ways? Can therapists change straight children to gay through therapy? I'm pretty sure it doesn't. This is just another attack on the gay community by conservatives who think being gay is a choice. Max, Baxter, 2 hours ago. Sad, sad day for science and the L.G.B.T.Q community, great day for quackery and religious nonsense. New Yorker, NYC, 2 hours ago. It seemed pretty clear that the court would strike down this ban. The link between conversion therapy and actual intent to cause harm, one of the things not covered by free speech protections, is thin. The upside is that now this should further protect gender-affirming counseling from state bans, but I'm sure some states will try to ban it anyway. Tom, Cleveland, 2 hours ago. I'm very curious why it was framed as a free speech issue and not as a medical issue. Couldn't Colorado have argued that talk therapy is a form of medicine dispensed by licensed professionals, not entirely unlikely a drug? And that talk therapy isn't regulated by the same norms but by professional guidelines. Len, Florida, 2 whores ago. No, therapists cannot just say anything even if it may be harmful. They are regulated by states and must operate using a code of ethics. And when medical and psychological organizations have determined that conversion therapy should not be practiced, it's not a matter of free speech for a therapist to do it anyway. It's simply what should be called malpractice. Steve, Seattle, 3 hours ago. There is a profound difference between conversion therapy that attempts to make a patient reject a part of themselves and attempting to resolve gender identity problems by expanding someone's concept of gender. If, say, a patient born a boy insists they are a girl because they are attracted to other boys, ought to be permissible for a psychiatrist to explain that boys can be attracted to other boys. But such an approach would fall afoul many state conversion therapy bans, as this would involve attempting to change a patient's stated gender. Thus, bans on conversion therapy in effect become mandates to instantly affirm a patient's stated gender identity. NY. 3 hours ago. I am on the fence here. From 20 to 40, out to family, brought boyfriends to family events. I lived as a gay man. At 40, I met a woman, fell in love, and sought therapy. Not to change my sexuality, but because I had developed a compulsive addiction to sex that was destroying any chance I had at real intimacy. My therapist was brilliant and ethical. He didn't push religion, he helped me understand myself. I have been married to the same woman for 27 years. I am 67. I live with integrity. That experience makes me cautious about blanket condemnations of therapy that touches sexuality. What my therapist did was not conversion therapy. He treated the compulsion, not the orientation. The distinction matters enormously. But here is what frightens me about today's ruling. That distinction requires a good therapist. What the court has now made possible is a bad one, the kind who will tell a frightened 15-year-old that God is the cure and shame is the method. The research is unambiguous. That version doesn't heal anyone, it breaks them. I am grateful I found the therapist I did. I mourn the kids who, because of this ruling, may be handed to someone else entirely. Someone who will call what they are a disease and try to cut it out with prayer. Something is being lost today, even if the law cannot quite name it. Quantum, NM, 3 hours ago. Is there a reason the article didn't explicitly and prominently state the ruling was 8-1? While deep in the middle of the article, the text states that Justice Brown was the sole dissenter. But shouldn't the lead have included something like, in a 8-1 ruling, justices reject Colorado law? Moderate voter, Washington State, 2 hours ago, at public interest lawyer. And as a retired public defender myself, while I intellectually understand the narrow finding by the other justices, I also recognize how Justice Jackson knows all too well the unintended consequences seemingly decent laws. Who is arguing a specific case and who is on the bench matters. It's not an academic outcome when you are dealing with people's lives in real time with very real and possibly irreversible consequences. Public interest lawyer, South Florida, 2 hours ago. This was the correct outcome. The First Amendment does not allow the government to prohibit speech based on its content. This is one of our most cherished freedoms, and there will come a time, as there often has been in the past, both recent and distant, when the shoe is on the other foot, and you will be glad it exists.
Thank you for watching this AGNDD Until I Report, dear viewers. Please like, subscribe, and click the bell button to get notified during new uploads. And make sure to tune in next time. Stay safe and healthy. Cheers.